Come on up. Senate Bill 842.
Good afternoon, Mr. Vice Chair and esteemed members of the Judicial Proceedings Committee. I am here to present Senate Bill 842. In 2025, I'm sorry. Yeah, in 2000, well, 10 years ago, I was called in my office downstairs, or is it upstairs? Here on the second floor. I was called and told that one of my students was incarcerated in Denver, Colorado. As most of you know, I am a retired school principal. And when they told me who it was, I thought about this student. And when they explained to me what was going on, that he was involved in a murder in Denver, I thought about him as my student at John Bain, and I followed him through middle school as I did most of my students, and made a decision to travel to Denver, Colorado, to see what was going on with my beloved student. Now, people say, now, that was not your child, but yes, it was. It's 2005 is when I made this decision. And after conversing with this youngster and finding out the circumstances that were involved, in which he was involved in a murder, I made a decision after he had served 22 years of his life incarcerated, that I would do something about the problem. And for 5 years, I traveled back and forth to Denver, Colorado, worked with a number of people, trying to ensure that once he was given a second opportunity, he would return back to the state of Maryland. We would mentor him, throw our loving arms around him, and help him to make a transition back into society. We even raised money to send him to college while he was incarcerated in Denver. We did a lot of things to help this youngster. After 5 years of our going back and forth, going to the legislature to change the laws, going to Capitol Hill, going to the Supreme Court to change some laws at the Supreme Court, we were very successful in getting him released because he was sentenced at the age of 16 to life without the possibility of parole. But because we changed the law in Denver, Colorado, we were able to get his release, put him on probation, and we brought him back to the great state of Maryland. We got him a little job, and we began to mentor him and counsel him. And I want you all to know that he went to college, did very well, never caused any problems. And he told us all that he had turned the corner when he was 21, at the age of 21. He said, I turned the corner and recognized that, first of all, I should not have been with a crowd, and number two, I'm extremely remorseful for what I did. We also were able to get counseling to help him to work through the problems that he was suffering, even as a child. So I knew his background. And so I made a decision to mentor him, and right now, he has moved to New York. He's got an excellent job and found somebody who would have him, and got married, and he is doing wonderful. Bought a house, and he's up in Schenectady, New York, in all of that snow. I'm still mentoring him and working with him. And we're talking now about a young student who was given a second look. And so I am here this afternoon to present to you this bill, Senate Bill 842. Because as I look at my students and as I look at youngsters all over the state of Maryland and even adults, we tend to paint all of our adults and children with the same brush. Some of our children and some of our adults are incarcerated because they did not have the financial means to even fight their case. In the case of this youngster that I'm talking about, when he went to court in Denver, the attorney came back and told us that she was very remorseful because she did not have the proper tools to really represent him. And that, of course, did not sit well with me at all after he had served 22 years of incarceration. Currently, the United States leads the world in incarceration of its citizens, with 2 million individuals currently in U.S. correctional facilities. Additionally, prisoners have been about 500% increase, have seen a 500% increase through the last 40 years. Amendments and changes to laws and policies used for sentencing, not changes in crime percentages, explain the vast majority of this increase. African Americans are being incarcerated in prison across the nation at almost 5 times the rate of their white counterparts. And Latino individuals, 1 in 3 times as likely to be in prison than non-Latino whites. This legislation ensures the fairness and justness of the imprisonment system in the state of Maryland. Unfortunately, Maryland is one of 12 states where more than half of the prison population is African American. Per the ACLU, the average yearly expense of imprisoning an elderly individual is $72,000 a year. And the population of older detainees in Maryland is substantially growing. This continues to create an increased financial burden as more of the detained population becomes elderly. This bill's purpose is to permit an individual serving a term of imprisonment to appeal to a court to alter or decrease the sentence under specific conditions. This does not mean that you open the floodgates and everybody is sent home. No, no. For the petitioner to have the choice to seek appeal after their conviction, they must first have completed both the accompanying impediments, served 20 years of the sentence without the utilization of diminution credits, or the equivalent of 25-year sentence with the utilization of diminution credits. This bill will also allow the victim of the crime or a representative of the victim of the crime to be granted the ability to present their objection to the petition's appeal of an altercation or reduction, alliteration or reduction of their sentence. In conclusion, this bill will assist with lessening the current financial burden that mass incarceration creates and that so many individuals face, while also guaranteeing that we maintain fair practices and empathetic sentences in our courts. I would ask that you please give this bill a favorable support. Senate Bill 842.
Thank you, Senator Benson. Before taking questions, let's get your panel up here. Ms. Elizabeth Hilliard and Ms. Monica Cooper.
You all know that I have to go back downstairs because we're in the process of voting.
Would anyone object?
I will stay just a little while.
Okay.
If you all don't mind, would you please excuse me? I know that you all enjoy seeing my beautiful face, but I'm going to have to leave you all in a little bit.
We do indeed. Whoever would like to go next.
Good afternoon. My name is Monica Cooper. I am the Executive Director of the Maryland Justice Project. I am a formerly incarcerated woman who served more than a decade behind a wall, and I will tell you, I didn't leave the same. After about 3 years, 2 years, 4 years, I wasn't the same person. And I sit here now as an elected official, 40th District Central Committee person. I'm sure many of you have been on Central Committee one time or two. Well, I was fortunate to gain the elections, the votes of my peers. I borrowed money from my grandmother for signs, and here I am. Also, I'm a college graduate, and I run my own organization. But I guess I'm saying all that to say is that people should get a second look. We have some bureaucratic things that say, okay, you put your, within 90 days, you put your modification in. That sometimes it's just not enough time to actually give a person the opportunity to think about the things you've done, to think about how you could change your life around, to benefit from therapeutic programs on the inside if you have them, to benefit from those things. So if a person has sit for 10, 15, or sometimes 20 years, I can tell you from my own experience that I wasn't the same person. And not only that, but my case manager could tell you, the people who I went up in front of parole could tell you, the person that I worked for in the shops could tell you, the correctional staff, which one of them I actually saw here today, she could tell you that I wasn't the same person. So when you have folks that can kind of chime in and said, well, this is not the person that they were 10 or 15 years ago, maybe you should give them a second look. So that's all I really wanted to say is that people do change. I know we're in a climate right now where there's a lot of stuff going on in the state, but there are some people who have come home and they own businesses. I started a solar energy company about a month ago. So some of you guys will hear from me. I'm going to need some help. But we are ambitious, and we want to pay taxes, and we want to get home, and we want to do the right things. Some people do learn their lesson. So to just write everybody off just like that is just not fair. And it's not fair to us. Instead of paying $40,000 a year, you get to create a tax base. My taxes are high. I said it to you a lot. I'm paying taxes. I don't mind paying into this tax base, but I think we can, think conservatively in terms of monies and amount of monies that you can save rather than having people behind a wall who can actually be out here doing well. I guess that's it. I can't believe y'all didn't say my time is up. I should just keep going just because. Thanks anyway.
Thank you so much. Go ahead. Just for the reason we have people at the podium is just because of where the camera is located. So if it didn't happen, no worries, but
Okay.
thank you.
I will take the podium then. Thank you, and I see that you made sure to make sure my time is running, so I appreciate that. Thank you, Vice Chair, members of the committee, Elizabeth Hilliard with the Maryland Office of the Public Defender. We want to thank the work that the General Assembly did in passing the JRA last year. It was a great step forward. This is the next necessary step. Allowing people who have served incredibly lengthy sentences an opportunity to petition for modification makes sense and is critical for 3 reasons. First, people change. Biologically, neurobiologically, through work, effort, and the enormity of serving a prison sentence, a person who walks through DOC's doors is never the same person who leaves. Second, the cost of mass incarceration to Maryland in both humanity and finances is abominable. We cannot continue to pay to incarcerate non-dangerous individuals. It is too expensive for the persons who are incarcerated, for their families, for their loved ones, and it is too expensive for Marylanders as a whole. Finally, I work in the Office of the Public Defender in post-conviction. I represent people who have served sentences longer than I have been alive. I can tell you that rehabilitation is possible, and it is critical to the way that we analyze our criminal system. For these reasons, we urge a favorable report on Senate Bill 842. Thank you.
Thank you so much. Senator Carter.
Thanks, Mr. Vice Chair. Just briefly, I'm glad you stayed, Senator Benson. I wanted to thank you for bringing the bill. Your story is always very, very touching, and I can't hear it too many times because it's a great reminder about injustice and how prevalent it can be to impact somebody's life. I just have a general question. So I think the bill is a good idea. It's always troubled me that a person gets 90 days to file a motion to modify or reduce a sentence, and then it's got to be heard within the 5 years, and then outside of the post-conviction, which is limited to, the effective system of counsel issue, there's really nothing else except what we created last year with JRA for the juvenile offender, or the juvenile, person that's convicted. My thought, and I heard what you said about the lengthy sentences, that's terrible. I've always thought we should do something to expand the 90-day limitation on the filing of that modification of sentence. And then in the early days, until some years ago, Ms. Hilliard, it's for you. So until a few years ago, we didn't have that five-year limit on when that had to be heard. And so I've thought we should do something to expand it generally. So I kind of wanted to get your thought. I know you like this bill, but even outside of this bill, do you think that there is a need to expand that 90-day time requirement and that 5-year, window that the person has to be heard?
Thank you for your question, Senator Carter. You've heard me say this before. I'm going to give you a very lawyerly answer, which is it's complicated and it depends. I certainly understand that part of the reason behind imposing those limitations is to afford some finality and some sort of certainty to victims. And I understand that it also sort of is a way to ensure that the judge is sort of put on notice that a motion for modification may be coming close in time to the sentencing. I think that there are many ways to approach what I would call sentencing reform or second look opportunities. This is one way. Changing the 90 days is another way. I think that this bill is particularly important and geared towards persons who are sentenced to long offenses who 5 years is maybe less than a quarter of the time that they've served. It's certainly not going to be sufficient to give the judge the opportunity to see their progress. There are certainly cases where 90 days or 5 years does make sense. For example, if someone is sentenced to 6 years or 7 years or even 10 years maybe that 5 years is a good middle ground. And I think that there are numerous ways to make a more workable option to permit a court to have authority. For example, maybe perhaps with a sentence that would put someone into local detention centers under 18 months, that could have a 90-day limit, and then the rest of the sentences could have the 5 year. I could see a graduated plan working very well to sort of tie to the person's sentence, but this is a good opportunity and a reasonable, I think, middle ground, accounting for both certainty and the opportunity to have a reconsideration.
Are you aware of any other states that either do the proposal under this bill or something similar to what you discussed as the graduated system, which could provide greater opportunity for more individuals?
Off the top of my head, I'm not sure. I know that there are numerous states that have enacted second look statutes that apply in various circumstances and to varying ages of populations. I can get more information and get it to you, though.
I'm sorry.
Use like red flashing lights. All right. Seeing no further questions, thank you both very much.
Thank you.
All right. So now that concludes the testimony for the proponents of the bill. We'll now switch over to the opposition panel. So is Kirk Wolfgang? You are. William Katz. Yep, Billy.
Good afternoon, ladies and gentlemen. My name is Kurt Wolfgang. I'm the Executive Director of the Maryland Crime Victims Resource Center. For over 40 years, we have dried the tears and held the hands and fought the legal battles for the crime victims of Maryland statewide. Before you incline to favor this proposal, I ask you to do your very best to see things from the crime victim's perspective. And that's a very dark place to try to take you. Descend with me into the despair at a level that few have ever tried to describe. English words fail to reflect the agony and the fear and the hopelessness of these crime victims. I'm going to, you have my written testimony. I'm going to skip forward a little bit to get to some of the examples that I would like you to try on to see what they would be like if you had to go through them or your family had to go through them. So all of these happen to our people that we've represented over the years. So imagine you're 8 years old and you're in the bed of your mother at home because your uncle's come to live there and you don't understand why, and his wife is very angry about it. So you ask your mommy if you can sleep in her bed that night. During that night, you wake up to the sounds of your mother shrieking in agony and fear as your aunt stabs her again and again and again and won't stop until all of her blood is in the bed and on your pajamas. Imagine that you learn on Good Friday that your firstborn daughter, the one who was to graduate next month with honors, that daughter who has been your best friend, was abducted and raped and sodomized repeatedly. Please read the testimony that I provided. It will give you the idea and the perspective that these crime victims go through. They do not want to be called to court repeatedly to try to ensure that justice is done. And I appreciate your time, and I'm available if questions are forthcoming.
Mr. Chairman, members of the committee, my name is William Katz. I'm an Assistant State's Attorney from Anne Arundel County, here on behalf of the Maryland State's Attorney.
Read the testimony that I provided. It will give you the idea and the perspective that these crime victims go through. They do not want to be called to court repeatedly to try to ensure that justice is done. And I appreciate your time, and I'm available if questions are forthcoming.
Mr. Chairman, members of the committee, my name is William Katz. I'm an Assistant State's Attorney from Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 842. Let me first of all point out the fact that under current law, current rules, a person can file a petition with the court within 90 days after having been sentenced. If a person is sentenced in the circuit court for less than 2 years, it would have to be through the a 90-day period to file a petition for reconsideration with the sentencing judge. There is provision for 2-year sentences or above. You can file for a 3-judge panel. The point is that that particular provision in our rules allows for a defendant/petitioner who perhaps as a result of a trial in which tensions were pretty high would have an opportunity to have that sentence reviewed by either a sentencing judge or a 3-judge panel, okay, in a perhaps somewhat more dispassionate environment. The tensions may have been very high. It may have been a very, very difficult trial. Emotions were sort of running amok, and in order to try to create a more suitable atmosphere, it gave the judge an opportunity to correct a sentence that perhaps he or she would not have otherwise given. The law was changed some years ago to allow the sentencing judge who has been the recipient of a petition for reconsideration to hold that sentence for a period of 5 years to maintain control over it. After that, it becomes the responsibility of the parole commission. What this bill really does is essentially take a single sentencing judge to fill the role of the parole commission. The parole commission is charged with the responsibility to determine how well or how poorly that person has progressed through the correctional system during the course of his or her commitment. I don't think we should substitute the judgment of a single judgment of the parole commission by enabling a single circuit court judge to basically trump the parole commission. I would urge this committee to give the bill an unfavorable report.
Wolfgang?
Yes, sir.
Yeah, I'm sorry, haven't seen a lot. So I just want to thank you for coming and testifying. I mean, it's sad that, you know, Virginia Roper's days are over, and unfortunately, the cries of the victims just don't ring very hallowed in these halls anymore. These are the days of injustice that's been foisted upon murderers and the like. That's what we listen to, and I'm sorry to say that your folks, we just can't hear them anymore. Thank you very much for coming in, sir.
Sorry, just my comment back to you is I understand that we're all concerned about the injustice in the sense of imbalance, racial imbalance and things of that nature. Our organization represents 70% people of color who are the victims of these crimes. I think it's seldom mentioned that there is another dynamic statistic, and that is who's the victims of these crimes.
Never mentioned. Thank you.
Mr. Chair, Mr. Wolfgang, just a quick question for you.
Yes, ma'am.
Again, thanks for coming in, and you testified about the victims that your organization represents. I disagree, though, with Senator Casserly. I think that we consider all sides of the issue. But one of the things that struck me is that you are aware that some crimes and some felonies and some sentences, people are serving sentences for crimes that don't necessarily involve a victim. They could be in there for money laundering or racketeering or possession with intent to distribute or distribution. You know, it's not always rape, murder, and those kinds of things where there's a specific identifiable victim.
Yes, Senator.
And then also, when we considered the legislation that we passed last year, we had a great deal of data that showed that over time, oftentimes victims, through time and through feeling like there was some modicum of justice served for them, that they don't necessarily feel this kind of vindictiveness where they want to see the initial culprit, you know, rot in jail for the rest of their lives. Haven't you come across that with some of your victims at times?
So let me answer the first part of that first, and that is nonviolent offenses that you're referring to. And frankly, I think I couldn't see, but I think it was your comment earlier about the 90 days to file. And I'm with you on that. I don't think there ought to be a 90-day limitation. I do think there ought to be a 5-year limitation, but not a 90-day limitation. That's just gamesmanship on the part of the courts, if you ask me. I will say that almost 100% of the time that motion to reconsider gets filed within the 90 days, but when it doesn't, it's just gamesmanship. Having said that, the nonviolent offenses, I don't think many of them are going to be at issue with this bill, because you're not going to find, in most instances, someone in prison after 20 years or 25 years on one of the nonviolent offenses that you referred to. And in terms of, I don't characterize it as vindictiveness. Please, if you do nothing else, I would appreciate it if you would read the testimony that I've sent. Those are not my comments. They're the comments of our clients who have come together on this issue almost unanimously in their opposition, and it's been over a 2-year period as, you know, we face this bill, previous bills, and other situations where the court tried to do it by rule. We came together. I was astonished at the unanimity of our clients on the issue, and it was across all racial and gender divides as well.
Well, I'll just say this. I assure you and everyone else that every senator on this committee takes the rights, the needs, and the desires of victims to heart. And that's why sometimes this work is inglorious, because the reforms of the last few years put us into a place where it's not always easy to talk about and are meant to correct past injustices and to rebalance a system. So I'd have to agree with Senator Carter with that. But thank you very much, and thank you for all your work.
Thank you, sir.
All right. With that, that'll end.